Good texter exemplifies the frustration, says, I'm 35 years old. I go out and vote. I tell people to vote. But how do you go out and vote for a candidate when none of them follow through on what they say they're going to do? It's exhausting. The sales pitches are never true. 35-year-old, 815er. You're 1,000% right. And I feel for you, but don't give it up. Thank you for telling people your age to vote. And literally, email your candidate. Ask your candidate. Go to wherever your candidate might be speaking and going, are you lying to me? Mm-hmm. Am I going to be able to go to you in 6 months and say, how come this didn't get done? Don't put up with just the standard BS that falls out of their mouths.
And sometimes they will write you back or call you back. I did it with the mail. Remember a year and a half ago or so when we weren't getting the mail?
They work for you.
I emailed the congresswoman, and someone from her staff called me and said, we're working on it. Thank you for your email.
Tell her you're Andrea. Do whatever you need to do.
I didn't say that now.
Evan Bernick is one of our favorite guests. Evan Bernick knows from the law. He is an NIU School of Law assistant professor. And the Supreme Court fall docket, as usual, has cases that are of great concern to America at large. We usually don't pay attention to these things, Evan, until the decisions come out months later. But what are you watching?
Good morning.
Hi.
Pleasure to be here, even in relatively chaotic times. So,
well, hold on, Evan. I just found out you've been named speaker. Congratulations, Evan Bernick. You're the new speaker.
Goodness. Yeah, well, I understand that I get a hefty salary for it, but it does seem to be even above my pay grade.
I tell you, I've been in the speaker's office. It's a sweet office. It's got a fireplace. Yeah, you'll like it. All right. So, what cases are you paying attention to?
So today there's actually a civil rights case that's pretty important. It may initially seem technical, but it has wide-ranging implications that I'm keeping an eye on. And it's basically about what it takes for someone who has been discriminated against to get into court. So civil rights laws like the Fair Housing Act, like the Americans with Disabilities Act, prohibit discrimination on the basis of legally protected characteristics, including race, sex, and the presence of disabilities. But as a constitutional matter, you can only get into court if you have a specific injury in fact. This is called standing. Deborah Laufer, in a case called Atkinson v. Hotels v. Laufer, being argued today, is a self-appointed civil rights tester. From her home in Florida, Laufer, who has multiple sclerosis and uses a wheelchair or a cane to move around, looks through the internet to find hotels whose websites don't provide information about the accessibility of the hotel's facilities, and she sues. She's sued over 600 hotels over the years, alleging that failure to provide information about...
Coming back.
Okay, disconnected, call back.
Yeah.
Point that he was making there is that particular woman with MS goes around and tests some of these hotels.
Yes, and they don't...
And to see if they live up to what they should be living up to.
Right, the standards that they should be.
But I'm curious how that got to the Supreme Court.
Yeah, I am too. A lot of these cases.
When you look around the city, you ever notice there's not a lot of curb cuts for the sidewalks where they should be?
Is that right?
Oh, yeah. We are.
By the way, the first place
behind the times.
The first place in the country to have curb cuts and to install them, if you will, Champaign-Urbana.
Oh, really?
Mm-hmm.
Champaign-Urbana. Let's bring them out right now.
Yes.
We got the professor.
But you're
back.
right. You're right.
Assistant Professor Evan Bernick back on the program. Good morning again.
Good morning, Steve. Where did I lose you?
We were talking about this woman who is a professional tester, if you will, dealing with her MS, trying to make sure these hotels and places are up to standards. And Nick brought up an interesting point off the air that we're in sore need of curb cuts in the curbs all around Chicago, and that we're violating those sorts of standards right in front of our own faces.
Right. So the question is whether the fact that she never intended to stay at the hotels that she has sought information about accessibility from prevents her from having the ability to sue. She is a civil rights tester. She does go around looking for violations of civil rights laws, but quite frankly, that was the kind of thing that was necessary to ensure enforcement of the Fair Housing Act. And the Supreme Court upheld the standing of people who were denied information about whether hotels would accommodate people on the basis of race. So the question is whether the Supreme Court is really going to impose new limits on the ability of civil rights plaintiffs to bring suit. Her motivations aside, the question of whether understanding that you are going to be discriminated against inflicts an injury upon you that should be able to get you into court.
There's no entrapment piece that would.
her.
There's no entrapment piece that would apply to any of this.
No, I mean, her motivations are whatever they are. If she's being discriminated against in violation of the law, she understands that. If she's being injured by it, there is Supreme Court precedent saying that is enough to get you into court.
So she's fighting for access. She's fighting for access literally and figuratively as well.
Yes. And the question is whether there's also a statutory question, whether under this particular statute you do have to make a reservation, irrespective of whether it would be constitutionally required that you do something like that.
Professor, I want to ask you about the Pulsifer case, which will be before the High Court this week. How should courts interpret the federal sentencing law that allows the defendant convicted of a nonviolent drug crime to avoid what would otherwise be a mandatory minimum sentence?
Yes, this is kind of a remarkable case because it really rests the fate of people who might otherwise spend decades in jail on a single word, and whether they need to satisfy 3 different conditions rather than simply one condition in order to be eligible for what's called a safety valve that will enable them to be released that will enable them to be not be subject to a mandatory minimum. The government is in the position of basically arguing that and means or, which is always an awkward situation to be in if you're dealing with a textualist who is suspicious of the criminal justice system, like, say, Neil Gorsuch, whose skepticism of this argument really became very clear on Monday. And it's kind of a good illustration of how what seems like a very technical case can actually have huge implications for people.
We fought for the fair maps issue here in Illinois. North Carolina's had some progress in this. The idea being the candidates pick the voters don't pick the candidates, and maps all around the country are so upside down. There's very few congressional seats that can actually be realistically flipped based on patterns of voter turnout. What about gerrymandering? There's a racial gerrymandering case coming up from South Carolina, right?
Yes, in a state with a particularly long and sordid history of racial discrimination, we have yet another redistricting case in which the argument is that we have a district that has been designed to discriminate on the basis of race on the pretext that we're just discriminating on the basis of political affiliation. Of course, those things are very tightly connected, particularly in South Carolina. The district court found that there was such discrimination, and the question is really whether the Supreme Court is going to, after a term in which it actually held the line against race-based gerrymandering, retrench on that a bit and second-guess the trial court which found discrimination.
Before we let you go, I wanted to ask you also about a case involving Purdue and OxyContin.
This is about the bankruptcy settlement?
Oh, yes. So that one I'm not as familiar with as I could be. I tend to focus.
That's not coming up till December, but for the second year in a row, there's a social media content argument that's coming up. First Amendment rights to free speech. I can post anything I want. Can states control it? Is it a federal issue? Where do you see that going?
So I see that going in the direction of finding that the Fifth Circuit, which basically treated social media companies as if they were government entities for the purposes of First Amendment law, that they could, that states could prevent them from engaging in censorship, as really a step beyond where the Supreme Court is prepared to go. The Supreme Court is committed to the idea that, corporations are constitutional persons. They have First Amendment rights, and effectively preventing them from moderating any content at all, which the Fifth Circuit held that Texas could do, is going to strike them as a bridge too far, except for perhaps Justice Thomas, who really seems to have it in for social media companies.
It's Evan Bernick. What are we doing in class today?
We are talking about criminal law. We're talking about homicide. It's going to be fun-filled and entertaining for all concerned.
I want to sit in on one of your classes,
we're
Professor.
We're talking about who shot Tupac. That's another thing that we're going to be talking about.
Oh,
yeah.
All right. Yeah, because that's a big news story in the last couple of weeks. Thanks for coming on. We always appreciate it.
Absolutely, Steve. Good talking with you.
Evan Bernick, assistant professor at IU Law. So there you go.